Okay, so my name is Jean-Pierre. I'm here to present to you. We're very happy to present Pierre Cotte, who's from the General Secretariat of the Council. Just a little bit of a background, biography. He has a very extensive career, an extensive bio. He's served in the French Ministry of Defense for 10 years, and has been with the EU for 13 years. He's been program manager, prime information systems architect at NATO, supporting 2 strategic plans. Since 2015, he's acted as digital transformation officer in the General Secretariat of the EU Council. Recently, he's been posted to the Justice and Home Affaire Directorate General to support the digital transformation of the justice within the EU on both the system and legislative aspects. So I will, the topic today will be the digital transformation in the EU Justice Cluster. And I'm very happy to present to you Pierre Cotte.
Thanks a lot. Is the sound okay?
Yes,
confirm?
I can hear you. Yeah.
Yeah. Thanks a lot. Yeah. So I start when you want. Yeah.
Sure. Please start. Thank you.
Okay, that's fine then. I had the pleasure last year to make a similar presentation. Actually, it was more on my experience of digital transformation. But this year, because I have more experience in this specific domain, which is the digitalization of justice, I will focus on justice because it's as such quite a substantial topic, and you'll see in a minute. Beforehand, just a few summary slides about what is the Council of the EU and what is the General Secretariat of the Council. So just a few summary slides. I will go quickly because it's not exactly the topic, but just to provide you a bit of context about what is the EU, what is the Council as such. So as you may know, there are basically 3 main institutions in the EU. So you have the Commission that makes some legislative proposals, and then these proposals are submitted and debated simultaneously at the European Council, where you have representatives of the member states, governments, and also of the parliament. Voilà. And you have also additional institutions such as the Court of Justice, which is of course of some interest for us in our domain, the European Central Bank, the Court of Auditors, and also you have a mediator. With that, you have all the institutions of the EU. Voilà. I will skip practicalities and the procedures because it's probably too far from our domain. Alors, the Council, the mandate is basically the 5 following topics: negotiate and adopt EU laws. That's the main topic. And that's what I'm doing in the justice domain, more specifically the digitalization of justice. But you also have to deal with policies and coordinate with member states' policy. It's of course a special topic, especially for the time being, on common foreign and security policy, as you can imagine, conclude international agreements, and adopt the EU budget. Voilà, here we are. So that's the Council itself is organized in 10 configurations, and you can read them from the screen. We'll just focus on the configuration number 9, which is the one I am supporting. So justice and home affairs. Voilà. So, and for the time being, as you can imagine, with the Ukrainian crisis, there is quite a lot of activities in this domain, because home affairs also deal with migrations, but you also have to, there are plenty of implications actually. So there are plenty of colleagues that are almost full-time on that. As far as I'm concerned, it's not the case. And I will talk to you about how the Council operates. So you have one configuration here. I can't tell you which one. So where the 27 member states are represented, you have a presidency chairing, and you have the Commission represented on the other side, plus the secretary somewhere. And the General Secretariat actually supports two councils, the European Council, which is composed of heads of states and governments. And that's what you see regularly on TV, where the head of states meet. But these people, they provide orientations, decisions, but they don't deal with legislative aspects. That's not their business. The legislative aspect is only addressed by the council, so the 10 configurations that I have mentioned. The subtlety about presidency is that the European Council has a permanent president, whereas the council is mainly a rotating presidency, so the member states rotate every 6 months. Just the Foreign Affairs Council configuration is chaired by the High Representative for Security and Foreign Policy. Voila. So we have also this issue that we have a rotating president. Voila. Which may be a problem, of course, because almost no action can be executed in 6 months. So you have to maintain momentum and hand over the knowledge and advise the new president about the current situation and the objectives. So for the time being, that's the French presidency that will end by end of June, so quite soon. And the next presidency is the Czech Republic. Voilà. And voilà, the GSC is supporting these two councils, the European Council and the Council of the EU. So let's talk about the main topic of today, which is digitalization of justice, that is basically named as e-justice, electronic justice. I will mainly focus on architectural views, helicopter views, of course, not too technical, not too detailed either. And then I will try and conclude on the challenges and the way forward. So basically, the justice domain is a challenge as such, because there are quite a few constraints that apply to the justice domain and the justice systems and the justice data. First of all, you have to differentiate, of course, the personal data and public data, and sometimes you have to deal with mixed data. That's the legend that you can see on the left-hand corner. And then the other thing is that each and every nation has its own system, and with its own procedures and its own language and terminology, its own authorities with their own mandate. So there is no easy mapping between all that. So, and of course, in the middle, you have the internet, and the idea is to build some interoperability in support of judicial procedures, so in support of the judicial authorities. And the solution has been, in the end, to put in place an infrastructure that is called e-codex, and that has required quite a substantial work for the last 10 or 15 years. And it's a way to basically build interoperability between two heterogeneous systems, so actually a peer-to-peer interconnection. And basically, for each and every procedure, judicial procedure, I give you some examples on the right-hand side, so service of document. By the way, traffic fines, you may know that if you exceed speed in Netherlands and you live in France, you may receive the traffic fine in France. That's an example. But also all the management of evidence, so either on the civil domain, which is called taking of evidence, or the criminal domain, which is called e-evidence. So all that is supported by data flows and procedures that are in the end supported by the e-codex. Our e-codex is actually composed of two components. The gateways, that's the infrastructure aspects for routing, mutual authentication and encryption, but also to deal with the transcription of the semantic and the syntax. You have a so-called connector that will interface with a national system and transpose the request and replies. So in a sense, every nation speaks its own language And in the middle, you have a kind of Esperanto, which is a common language for the whole EU. So that's a technical view that doesn't bring much more information, just the fact that there is, of course, a central testing platform, CTP, and you have a central management tool, of course, to configuration manage all that. For the time being, this system is maintained by a consortium composed of reps from 4 member states. So Germany, France, Netherlands, and Spain. Voila. And in terms of operational view, it's an example. Judicial system in France will send a request to, in this context, a Polish court, and there will be a reply in accordance with a predefined procedure. Of some interest, you should note that the components are open source, and so you can find them, and the generic term for them is called e-delivery, and it's part of the CEF, so the CEF initiative that you have heard about just in the previous presentation, if I'm not mistaken, which is Connecting Europe Facility. Voilà. And this building block is that has required quite some effort to be, so both the connectors and the gateways. And it's now operational. You have a few examples on the right-hand side. So let me just read through: European order of payment, European small claims, mutual recognition of financial penalties, and mutual legal assistance in criminal matters. And you have also EIO, which is European investigation orders. So all that, and there are procedures and legislative instruments behind, all that is supported by eCodex. So, but eCodex is one thing. It's an infrastructure which supports legislative, judicial procedures, but you also have a bunch of registries that are mainly maintained by the nations, by the EU member states. You have a bunch of registries, registry of population, registry of birth, registry of death, registry of last will, land registry, and so on and so forth. There are plenty of registries. It depends, of course, on the member states, because in some member states, these registries are directly maintained by the Ministry of Justice, for example, in Sweden, whereas in many other countries, there are notaries, for example, that deal with a significant portion of those registries. Actually, in 22 out of the 27 EU member states, you have a profession of notaries that basically deal with all those registries. But also you have also legal practitioners that have their own registry in their own specific domains, such as the bailiffs, the expert, or the mediators. Voilà. And the EU has put in place an e-justice portal, and through the e-justice portal, you can launch some requests, such as find a bailiff or find a notary in a distinct EU member state. Of course, it goes via the search engines such as Google, but it's interconnected, and it will fetch the data from the national registries. Voilà. And it's pretty efficient. Of course, the member states, they put their own national registry available for their own population. So if you search in your own country, there's no need to go via the e-justice portal. But if you search in a distinct EU member state, then it makes sense to go via the EU e-justice portal. So that's typically the front end of the e-justice portal. You have 25 languages in operation, and you have all the topics of interest that you can see on the right-hand side, such as family matters and inheritance, money, monetary claim, court procedures, and so on and so forth. If you're interested, you can, of course, go to the portal and have a closer look at that. There is a lot of information and services available on this portal. So we have talked about the infrastructure, we have talked about the registries. There are some more elements in the justice domain, such as the court database, which is in fact built and maintained by the national judicial authorities, each for their own, of course, judicial authorities. And all that is made available via a global court database where you basically map the judicial procedures and the national judicial authorities. So if, for example, you say, I want to launch a small claim against a company in Germany, imagine you are in France or Spain, whatever, then you go to this, you go to the e-justice portal, you try and find the judicial authority which may be in charge of this specific request. You will browse the court database, spot the authority that may have the authority to deal with the case, and then you can trigger the request. Well, you can trigger it by mail for sure, but you can of course trigger it by a digital procedure, and that's basically the next slide. So the next slide is about a new ambition, which is starting to materialize now, is to launch some digital procedures at European level. So there's a kind of access point that will, in fact, mediate with the e-codex infrastructure and the national systems. For example, if you ask for a reimbursement, if you have a small claim and you ask for a reimbursement, you can trigger the procedure, which is called small claim, and you can send it to the required national authority of via the access point and the e-codex infrastructure. And then it will be addressed, successfully or not, it depends, of course, by the national authority on the other side. The same apply for the legal practitioners. So, for example, if you have a European payment order, and that should be executed in a distinct EU member state, but you do the same via the same access point, the same e-codex infrastructure, but this time it will be routed towards the systems of a legal practitioner. So in this context, it will be a bailiff that will be in charge of handling the European payment order in the other country. So that gives you an idea of how the data flows and the procedures will be supported in the coming years. So for your information, the European access point will be the result of an ongoing legislative procedure. So it's not fully operational. There are still some procedures that are supported, and precisely small claims and European payment order. That's the reason why they are depicted on this slide. On the portal itself, at the access point, the issue is, of course, to provide adequate identification and authentication of the end users. Then the difficulty is, as I mentioned, to identify the judicial authority that will be in charge in a cross-border scenario, of course. And last, to follow the progress of the procedure, and you typically need some acknowledgement. To start with, a communication acknowledgement to make sure that the request has actually been transferred, and in a second step, a procedural acknowledgement to make sure that the authority that will seize the request and address it properly. It may well be, if you have made a mistake in addressing the judicial authority, that the request has to be rerouted, of course. So that's the holistic view of a judicial domain. So you have all the key components here, but it's still a simplified view. There are other facets that I didn't want to describe, but it gives you an idea of a topic, of a challenge at the same time. The only thing which is missing, of course, in this slide is the number of procedures that will be supported. And it's about 30 procedures altogether. So you have, for each and every procedure, you have to customize, of course, the the access point with a semantic and syntactic transcription in each and every EU member state. So it's a bit time consuming, but it's operational, and there is no feasibility question. It's just a question of standardization, consensus, and of course, effort. Voilà. Alors, in addition to that, yes, for your background, there is a huge database which deals with law and case law. It's called EURLEX. And again, it's 25 languages. You see on the right-hand side, the front page deals with EU law and EU case law. And you have also the national law and national case law that relate to the EU law. Not necessarily everything, but at least all that relates to EU law. And voilà, I will conclude on the challenges and of course the key concepts and the context. So first of all, I've mentioned that in the intro, the notion of independence of a judiciary is a critical driver, and it cannot be prejudiced because you deal with digital transformation, of course. So you have to make a kind of separation of data. You cannot mix judicial data with data from other domains. You have to enforce need to know. It's dedicated budget. You have to prevent conflict of interest. You have to make a service level agreement with the IT suppliers, and so on and so forth. So that's a challenge. The other driver, of course, is the accessibility to law and case law. That should be guaranteed. So, and that's the reason why you have typically these two portals, so the e-justice portal and the EURLEX about law and case law. In addition to that, as you can imagine, there is a need to anonymize or pseudonymize the court decisions, and possibly to remove the names of the people at start or on the later on, because of a GDPR regulation, you cannot expose people for a long period of time. It's also a countermeasure to avoid the judicial authorities to be profiled. Voilà, alors compliance with EU and national law, of course. Now you have typically two horizontal law that needs to be considered, the need for transparency and data privacy. Those are two laws. You also have a more technical law, which is called eIDAS. It is for identification and of authentication services. Voilà. And you have, of course, criminal, civil, and commercial laws that materialize via either regulations that are immediately applicable to all EU member states, or directives that need to be transposed in national laws. And the cross-border information exchanges that indeed on a peer-to-peer basis, the judicial authorities don't want any central information hub, no, not even a central monitoring system. So that's the reason why this architecture has been adopted. I mean, the e-codex infrastructure. And you need for, there's a need for standardization and security, and interconnection, of course, of backend systems with e-codex, EU infrastructure, need for transparency. The justice domain also maintain huge open data sets at national or EU level, and there's a dedicated portal on that. Yeah, so that, but it's more about the execution, the statistics, the feedbacks. So, and all that is also made available. It's managed by the Publication Office of the EU that is located in Luxembourg. Voilà. I've been talking about architecture until now. Just two slides on the operating model. Well, it's indicative because it's high-level view. So, but it's interesting to note that we have developed a kind of model for the justice domain. So there are, of course, 4 central processes, which is the stakeholders, the national stakeholders mainly that lead that domain, the users. You have operators and agencies supporting their own system. But in addition to that, you have, at operational level, you have 5 processes or the concept to deal with conception, moderation, coordination, implementation of project, the legislate procedure that deals with regulation and directives, and text experiments, because we also deal with pilot projects. And at strategic level, you have what you can easily expect there, because it's in the COVID-5 model: monitor, evaluate, and direct. Voila. So to keep it short, you have the e-justice operation, which is composed of 4 central processes. All around, you have the e-justice transformation domain. And on top, with no surprise, you have e-justice governance. And all that is supposedly assigned to national or EU authorities. I will not go into detail, it's complex, as you can imagine, but that's the pattern, that's the template. And the working party, which is advisory board that provide advice to the Justice and Home Affairs Council configuration that I have mentioned up front, is dealing with basically the following 7 topics that we have called swim lanes. And I will go quickly. The moderation lane, that it is all about collecting user requirements, expectations and concerns, and communicate with users. You have then the legislative lane, where you draft or update legislations and coordinate with other working parties. You have a strategic lane to harness the user experience and reporting and elaborate the EU e-justice strategy. You have a governance lane supervising the action plan project, because we also have an action plan and composed of 25 projects, and we elaborate plan and policy guidelines here too. The operation lane, which is all about ensuring the operational coordination and synchronizing plans with stakeholders. You have a monitoring lane where you monitor risk and opportunities, such as new technologies or new laws at national level, for example, and national e-justice services, because you also have to monitor the way the member states digitalize their own justice domain. And last but not least, the innovation lane, where it's all about conceiving, implementing, and testing innovative use cases. That's, in practice, it has been, that's my last slide, if I'm not mistaken. It has been implemented more or less this way. It's high level for sure. The sponsoring of the initiative, that's for the EU Commission, of course. And basically, there are 2 programs that can be used: the Digital Europe program that you have heard about just before. But you have also, as you may know, the Recovery and Resilience Facility program, which has itself 4 main topics: environmental sustainability, productivity, fairness, and macroeconomic stability. And as far as e-justice is concerned, it's mainly under productivity. So there are about 20% of the budget that will deal with productivity and also a lot of e-justice initiatives, as far as I remember. You have the details below with the hyperlink. Then about coordination, harmonization, and sharing experience, you have a working party on e-justice that I am directly supporting, and you also have expert groups on specific matters, such as Ecole, for example. Then you have all the legal instruments, which involves, as I mentioned before, the European Parliament, the Council, and also the EU Commission. Legislation, you have to differentiate regulations and directives, and that's high level, that's primary law. And then you have implementing acts that are elaborated by the Commission when it is about, for example, the security profiles. It's not in the law itself, because it will evolve over time. So all that is designed and developed via implementing acts. There is some technical support required, of course. So you have a EU Commission, namely the Directorate General for IT, called DIGIT. And you have also, in the context of e-Codex, a consortium that has been put in place for now 6 or 7 years, and you will soon have a EU-LISA agency located in Strasbourg and in Tallinn in Estonia that will be involved quite soon. Voilà. The publication of justice information, it's on the e-justice portal operated by the EU Commission, or the EURLEX portal, which is about law and case law, or, as I mentioned, the EU data portal, which is where you have all the open data published there. Voilà. And all that, the latter two actually are operated by the publication office of the EU. But that gives you an idea of the activities, challenges, and objectives of in the e-justice domain. That concludes my presentation, and now I can deal with questions.
Thank you, Pierre. Very, very excellently presented. There's just so much to the topic, that's for sure. We have a couple of questions. Oh, and so we can go with the first one here. It says, I assume only legal practitioners have access to the e-justice portal. Is the training and certification process, is there a central body at the EU level to maintain the system, or are there teams on board at member states?
That's a good question. It's not strictly true. Of course, all the legal practitioners have access to the e-justice portal. But the citizens also have access. Of course, they don't have access exactly at the same space, because citizens cannot have full access to all registries. That's not legal or even possible. But the citizens have access to the e-justice portal. And now about the contribution of the member states, they do contribute. They do contribute. Alors, they either contribute directly. There are areas where they have to populate their own documents and data, or in some areas, thanks to standardization and automation. Basically, there are two initiatives in this domain called ELI and ECLI. ELI is European Legislative Information, and ECLI is European Law Information, and ECLI is European Case Law Information. There's a kind of standardization with based on XML, and you can extract directly from national servers the data and feed the EU portal with national data in correspondence with EU law, for example. So it's mainly automated. I'm not an expert in this domain, but it's pretty operational and pretty satisfactory. So just to sum up, the e-justice portal is not only for the legal practitioners, but also for the citizen, although they don't have the same, of course, need-to-know rights. And the member states do contribute to the population of data on the e-justice portal, but either they do it manually, but more and more automatically via interoperability features.
Excellent. Thank you for that response. Okay, we have one more question. If anyone has any other questions, feel free to go to the Q&A section and put your questions there. Another question we have. Currently, if I have an expensive speeding ticket in Germany but reside in France, what are the chances that I'll be tracked down for compliance enforcement actions against me?
I'm sorry, but the sound was a bit. Could you just repeat the question?
Absolutely. I guess the gist of the question is, what is the likelihood of those cross-country fines for speeding, I guess, actually being enforced in Europe?
But altogether, no, the dynamics of the justice domain is not bad in the end. The point is, of course, there is probably too much time assigned to legislation, because altogether it takes typically 5 years for the Commission to draft a proposal, then to submit it to both Parliament and Council, and then it is adopted, and also you need implementing acts, because as such it's not directly operational. So yes, the process time consuming. It takes 5 years minimum. And there are examples of laws that took more than 5 years, huh? No problem. So the difficulty that we have, and it's no surprise, I think, for the audience, when you deal with a digital transformation, you cannot put everything in sequence. Otherwise, it will take 20 years in the end. So you have to do a bit of concurrent engineering and do the conception, the collection of user requirements and the prototyping and all that in parallel to the legislative activity. Otherwise, when you have a green light, if you have to start from a blank sheet of paper, you put another at least 5 years at last, and it's too long to satisfy basically anybody, starting with the stakeholders and the national authorities. So yes, the question about the dynamics and the procedure, the operating model, let's put it this way, is critical, and we definitely have to be creative in this area, because a traditional, sequential, if not bureaucratic scenario where everything is in sequence is far too long and certainly not satisfactory. So yes, there is still some uncertainty about how well and how far and how quick the EU will be able to materialize all those all those objectives. And yes, there might be some casualties in this scenario. We cannot guarantee that everything will go smoothly, but actually, it also depends on the motivation and involvement of the member states. And when there is a commitment from them on their side, it goes pretty well altogether. Even if at the end of the day, the result is not necessarily reached at 27. Sometimes there are only 20 or 25. Maybe still some missing member states at passing the arrival line, but okay, no big deal. It can still be remedied in a second step. So yeah, it's a question of motivation. It's a question of engagement, especially on national level. It may well be that some topics are not too popular and the motivation may be low in some areas. That's correct. It's difficult to predict, to tell the truth.
Okay, thank you. So I guess I've got a question for you. It might be a little bit more on the technical side, I guess. It just seems like such an enormous task to try and deal with 27 member states and the identities and the exchange of that information. Do you want to talk a little bit more about the challenges there that you're aware of, and maybe what inroads you've been able to make? Just to give a bit of a background, we're also working on what's called the Pan-Canadian Trust Framework as well, and sort of trying to look at identity and authentication and so on in that way. So just maybe you could speak a little bit about that. I can't imagine it's an easy thing.
No, there are, but as we say in English, the devil is in the detail, and of course, when you deal with the practicalities, such as indeed identification and authentication, that's problematic because, as you can imagine, not every EU member state has reached the same maturity on these domains. And of course, you are dependent on the member states because you will not deal with user identification or authentication at EU level. That's obviously a national prerogative. So that's a problem. That's a problem for all the actors, and not only the EU. That's a problem for the legal practitioners. By the way, during the COVID situation, I give you an example. The notaries had to organize some remote sessions to establish some acts. And for example, you had a German citizen that wanted to acquire a property in France or vice versa, it doesn't matter. And then you had two notaries involved on each side, and the notaries had to authenticate themselves, so they had to trust each other. And on each side, so for example, in this context, the German notary had to identify and authenticate the German citizen acquiring a property, and on the other side, the French notary had to trust the German notary to finalize the act. So it has been relatively successful. In the end, people had to be creative, but at the same time, there are also risks involved, as you can imagine. So visual recognition is certainly a key factor, but at the same time, you may know that in certain countries, such as in France, for example, you cannot share visual pictures of people to avoid discrimination and for data privacy reasons. So sometimes there are some conflicting requirements and objectives in this regard. Another example is, of course, the electronic ID, the card, because as you know, some countries are pretty advanced in this area, starting, for example, with Belgium or Estonia, and there are others where we have already had, because I'm Belgian resident, digital ID. So you can easily authenticate via your Belgian ID if you live in Belgium. But in France, it's not the case. So that's another problem. So then you have to be creative, because the procedure may not be fully digital. In some areas, you have to visit the city hall and authenticate yourself, and then you will be given a credential. Then you can connect on your account on the e-justice portal to launch a procedure, something like that. So it's a kind of hybrid scenario. We cannot go 100% full digital in the first step, because it's too problematic in many areas, starting indeed with authentication and identification. But there is another domain which is equally problematic, is to manage and guarantee the authenticity of the documents. And it's all about digital signatures, and that's another area of concern as well. But I won't be too explicit about that.
Okay, well, that's a great answer. Thank you for that. We have some other questions here. Let me just pull one up here. Let's see here. Sorry if I missed it, but do the member states code their archive too for X codex, or do they just use e-codex starting from an agreed cutoff date?
Good question. I don't know. They don't make the archives available. They keep that for themselves. But there is a policy, in fact, in the justice domain and in the EU, which is you have to, when a judicial law, a judicial decision has been made, it has to be made available for a certain period of time. It depends on the domain, which is commercial, civil, or criminal. The question of pseudonymization or anonymization of a decision is one thing, but in any case, the decision has to be made available. That's the reason why we so much attention on case law, because all the decision has to be made available for typically 10 years, and only after you can remove the decision, and then it becomes a national prerogative. So the archives are not available, but the decisions are made, whether at EU level or at national level, are made available for typically 10 years.
Well, thanks again for that. One last question, if that's okay. Here I've got, out of 7 swim lanes for e-justice, where is EU currently easily swimming, and which lanes have there been challenges?
Well, that's the good question. To be sincere, the e-justice was swimming for the last 10 years in technical and operational lanes, and that's the reason why there was so much focus and attention on the e-codex infrastructure and all the related activities. But now the situation has changed recently. Now the working party deal with legislations, and the first legislation has been passed, which is the e-codex legislation, basically, where it has been decided that the responsibility, the operational responsibility will be handed over to EU LISA in Tallinn. So, and now there's another legislative proposal on the table, and guess what? Now the attention of the working party is mainly swimming in the legislation lane, and less attention has been devoted to technical and operational matters. Of course, we have to find out a good balance. I would say we have a 50-50 scenario, because if all the attention goes to legislation and nothing happens anymore in the operation on technical and operational topics, then of course it will be a kind of a dead end for the e-justice domain. So, and we are still juggling for the time being. This situation is new. We haven't yet fully found out the solution. It also depends on each and every rotating presidency, but no secret, at political level, people are more interested in legislation because it's visible, as opposed to technical and operational topics that are, of course, not only invisible, but also cryptic. So yes, it's a problem. The point is to swim in the 7 lanes and not only in the 1 lane, which is called legislation. But that's a challenge.
Thank you very much, Pierre Cotte. It has been a pleasure to hear you speak on the topic, and I fully appreciate the challenges that you face, and it seems like it's in good hands. Thanks again for presenting. Very much appreciated, and wish you all the best.
Thank you. Thank you so much. Have fun for the rest of the day.
Thanks.
See you. See you.
And see you. And for everyone else, I guess we'll be seeing you later. There's a lunch break, and we'll be starting back up at 12:30 in the streams. Thanks very much. I'll just be holding off for a second now while the video catches up. So thank you.